Welcome to the Empower Series Online. For those of you who are new, my name is Clifton Johnson. I'm the founder of the Empower Series Incorporated, which is a 501c3 nonprofit organization brought to you by the generous donations of Comerica Bank, AE Media Group, and you, our viewers in the United States and around the world. If you want to find out more about the Empower Series, you definitely got to check us out on our social media account. We're on LinkedIn, Instagram, Twitter, YouTube. You're on YouTube right now, so while you're on YouTube, go ahead and like us, subscribe if you haven't subscribed. Definitely make comments and share us with someone else. The only way someone's going to find out about the Empower Series is if you share it with them. So there's somebody in your circle that can definitely be empowered and inspired by the Empower Series, so don't keep us a secret. Our website is www.empowerseries.com. There you can find out more about how we deliver hope, inspiration, education, connecting people to resources to achieve their goal. In the top left-hand corner, you can click on the donate button. So if you make a donation, we greatly appreciate that. And today's session is going to be on estate planning. For those of you who don't know this, October is National Estate Planning Awareness Month, and that is the month where we focus on the importance of making sure people understand what estate planning is and how that can be used in their overall plan to really make sure that their loved ones are not dealing with these decisions when they're really grieving your loss right now. And actually in the 2021, the week of October 18th through the 24th is National Estate Planning Awareness Week. So that being said, as we talk about estate planning, most people think estate planning is for the wealthy people, but I would tell you that we all leave behind the same, which are people that we love, our family members that are really impacted by our loss. So those of you may have heard of Howard Hughes before. So back during his day, he was one of the most influential and financially successful individuals in the world. He was a business magnate, he was an investor, a record-setting pilot, he was an engineer, he was a film director, and a philanthropist. And when he died in 1976, his estate was actually worth $2.5 billion. In today's dollars, that's like $11 billion. But believe it or not, to this day, 45 years after his death, they still can't find his will. So I would tell you, estate planning is not just for the wealthy, it's really for everyone. Because we're all going to leave behind the same as Howard Hughes, pretty much everything. You've never seen a U-Haul driving behind a hearse. At the end of the day, we cannot take it with us. The one thing that we all have, though, are people in our lives that love us and are going to be emotionally impacted by our loss. So that being said, I want to really make sure that we're talking about what is estate planning, how it affects you, and we have professionals as our guests who deal with this on a daily basis. They're on the front line. So our guest is Anna Hernandez-Pace. She is an attorney for Shutt Law Firm, and she specializes in estate planning, as well as probate litigation, as well as probate alternative strategies. And then we have a financial advisor by the name of Adam Keller. He is a Certified Financial Planner Practitioner. He works for Three Oaks Financial Advisory Group. He's been in the business for 16 years. So welcome to the Empower Series.
Glad to be here. Thanks for having us.
Well, this is a very important topic to me because, as I've shared with you before, my brother passed away just last year of COVID, and I had to go through this process. And we all have family members or friends that we've seen go through this process for the first time. So I just want to thank you for not only taking a portion out of your life to really invest and share with the Empower Series community, but really being on the front line of helping the thousands of your clients mitigate the emotional distress that they have to go through in losing a loved one and then making these kind of financial decisions. So tell me a little bit about your practice first before we get into this. Anna, so what do you actually do for your clients in estate planning and probate?
So we do estate planning, which will help people prepare for not just death, but also incapacity. Right now especially, I think people are becoming aware that you could have a stroke at 40, or you could, be on a ventilator or get COVID, and, pretty much when you're in the hospital, out of breath, the last thing you want to worry about is, oh my God, I didn't do any of the things I should have done for my family. I don't like to get phone calls telling me, oh, can you come to the hospital to sign his will? So it's nice when people realize I need to get my estate planning done, right? Not just for when I'm dead, but for myself, so that way I'm taken care of. Then I also do guardianship. So when you can no longer care for yourself, or because you failed to make financial powers of attorney or medical power of attorney, you'll be reaching out to me to help your family or loved one get that care they need. And then we also do probate, which is after someone has passed, you usually have to, well, you usually or you may need to probate a will. So you'll be reaching out to a probate attorney. And then we also do a special needs planning. So if you have a kid with autism or, or a disability, you also may need to do some special needs trusts, because if that child receives money and he is on SSI or Medicaid, he may be disqualified because of inheritance.
So what's really important that you talked about is that this estate planning is not just when you pass away.
Right.
I know that we've all had elderly parents or aunts and uncles that at some point just can't handle the daily function of paying their bills or things of that nature. So really having a strategy in place to talk about when I'm not able to handle the daily functions that I normally handle, what do I put in place to ensure that I have someone who's trustworthy that can really take care of these things that are very important for me, and that's before you pass away.
That's right. You spend all this time amassing all this, I guess, wealth or money so you'd be fine, but then you don't realize, what if I do have the money, but then there's nobody to take care of me?
Right,
So I think that's the next stage to think about.
Yeah, and we'll talk about this too, because you talk about people who have money, but this estate planning process is for everyone,
right,
regardless of whether you have money or not. So we definitely want to make sure that we're helping people at wherever they are on that economic ladder.
Right, because that's the most frequent thing I guess we get told, which is, but I don't have any money, so I don't need it, right? And I tell people when they call me and they say, look, my family member left this little bitty of money, and I have to tell them, well, you might as well leave it there because it's going to cost a lot of money to take it out because they failed to do their estate planning.
Yeah, and then the other thing we'll talk about are the resources that they can use. So definitely they can talk to either one of you. I really encourage people to talk to a financial advisor. And so I'm also curious to know about your practice, Adam, and then how do you guys work together?
Great. Yeah, so as you mentioned, 16 years in the business, and you gave me way too much credit saying thousands of clients. We work with about 270. Anna is a way bigger deal, and she works with.
Wait. In 16 years, you had to talk to thousands of people, right?
True.
That's what I'm talking about, bro.
Good point. Good point. Look, my ego was already puffed up, and now I feel like I'm a big person. No, but we tend to specialize in working with clients in a collaborative manner, and what that really means is understanding that as financial advisors and certified financial planners, we are kind of a jack of all trades, but experts in none. So what we know is how to speak the same language as the attorney, as the CPA, as the lender, and basically be an advocate for the client in all those situations. And Anna can probably attest in some of our cases, sometimes we maybe get in the way, but we are really good facilitators of making sure that things are coordinated. And especially on the estate planning route, I think what we find is that it can be a complicated process, and sometimes even when it's a simple process, there are so many boxes to check that things can be left undone. So we can be an accountability partner. When the attorneys and the professionals give us the instructions, we get to help the client make sure they actually implement it so that something they've spent time to construct flows in the manner they wanted. A great example is Anna may have helped them with the will and the incapacity planning documents, and she may have seen that they had 3 bank accounts and said, look, for this $1,000 bank account, if you put this kind of designation on it, it bypasses the probate process,
right,
so that your family doesn't have to go pay $1,000 for probate costs to emancipate that $1,000, right? It happens automatically.
Right.
Not automatically, there's a process, but it's an inexpensive and quick process. So,
Well, I'm glad you brought that up as an example, because a lot of times, we're going to talk about a lot of things. It's going to be very valuable, but it's going to be educational. So you're not practicing law on this show right now. So before we get too deep involved in this, I definitely want to make sure there's going to be some disclosures on the screen. But if you need to say something to kind of qualify the type of advice or information you're going to be sharing, how would you describe that to our audience?
This is also very educational, so nothing is... All right, so yes, this information is not intended to be legal advice. It's not catered to any particular person's situation or needs. Before you take action or, abstain from taking action, please make sure you talk to have a consultation with an attorney or a financial advisor to kind of steer you to the right person for your help.
Yeah, so definitely in our program today, I want to accomplish 4 things, basically. I want to give people hope that whatever they envision happening for their family can be done. I want to inspire them to take action. And like you said, whether that's meeting with a professional to get the actual advice tailored for their needs, they do that. We're definitely going to be educating them. So the training, we're going to share some information that is new. So it's always important to increase our knowledge base, but most importantly, it's connecting them to resources. So whether it's a professional like an attorney or a financial advisor, or going to a government agency or a nonprofit organization, definitely don't sit on this information. Take action and get the advice from a professional. And then the same with you as well. As a financial advisor, you definitely don't practice law or accounting or,
This is true. No, nothing that comes out of this mouth is intended to be legal advice, tax advice, and I think to Anna's point, this is for educational purposes. This is not meant to be your specific solution. Per Clifton's verbiage, there will be a disclaimer so that I don't miss saying anything I'm supposed to say for our legal department. So please read the disclaimer.
So what I want to cover though, and this is what we're going to talk about, we're going to define what estate planning is and why it's important. We're going to talk about the tools of estate planning, and then we're going to use some examples to really help people see how this fits someone who may not have a lot of wealth and they may want to use a probate alternative strategy. Someone who might be in the middle class and they have some assets that it may be beneficial for them to go through the probate process, and then maybe a high net worth individual. But let's kind of start with how you guys work together and how do you define and introduce estate planning to your clients? I don't know who wants to start with that.
Do you want me to start on that one?
Please.
Okay. So when we engage with a client in the discovery process, which is usually the introductory meeting, one of the first questions, and as a matter of fact, it's in our data gathering sheets, do you have an estate plan? And again, that term in and of itself sometimes is confusing. So then we elaborate a little bit further and ask, do you have wills? Do you have trusts? Do you have incapacity planning documents? Is your estate attorney a key decision maker for you? And so I think we look to find and uncover what is already existing in place. We also want to know about beneficiary designations. So we tend to ask a lot of questions up front that enable us to understand where we are today at point A. We get really deep into what the client's goals are. Mm-hmm. And as we understand those, that is typically when, if we see a deficiency or an opportunity to update an existing but maybe antiquated plan, our red flags start going up and we say, oh my gosh, we need to bring in another professional because we can talk strategy all day with you, but we can't implement it until we get the attorney. And that's usually when we're calling Anna and her team and the attorneys with whom we work and really introducing and facilitating that. And before the cameras turned on, we were talking a little bit about this process, and sometimes clients are intimidated at the thought of going to talk to an attorney because they're like, I don't even know what I need to go ask for, even if we give them a list and a menu. And so a lot of times what our role is in this process and the collaborative approach is being with them as an advocate, to be a backstop, to let them know, again, we speak that same language, and then kind of getting out of the way. Because the attorney does their job way better than we could do it. And so part of it is it's hard for this guy of knowing when to shut up and let them do their thing too.
So I think that's interesting because you, as an advisor, you may know a lot about their situation, their goals, and their aspirations. You may begin the estate planning conversation, but definitely an attorney needs to be involved to really implement the tools. And maybe in that conversation, they'll share things that they won't share with you, right? So in that initial meeting, you may have an in-depth conversation about what their intentions are. You're accumulating wealth, but then you talk about it at some point. Tomorrow's not guaranteed, and so what happens if you don't wake up before you accumulate your goal? What if you live for a very long time, you've accumulated your goal, and you don't wake up? But then also, what happens if you wake up and you can't do what you normally do to generate wealth? And so you have those initial conversations, you get that information, and then you find there's an opportunity to introduce them to an attorney. And then how does that work once Adam introduces you to a potential client? What do you do next?
So when I get a person in our office, it's usually either because someone has been smart enough like Adam and said, hey, you don't have anything in place. People, when I ask people, do you have estate planning? Do you have a will? They say, well, I don't need to. I have an insurance policy and I have a beneficiary designation, right? And I think, that's why it's nice to have a financial advisor, because he'll make you think of more than just those financial tools like insurance or beneficiary designations. They'll actually ask you, do you have incapacity planning? Do you have a will? Do you have a trust? Do you need a trust, right? And then they will steer it this way, right? And then we also do the same thing. Sometimes we have clients who are getting $30 or $100 or $150,000, and they've not ever had a cent like that before, right? They've never dealt with, tens of thousands of dollars, and they don't know how to invest their money. And we say, look, you are welcome to go and spend it, buy a new car, buy rental properties, but maybe you should talk to a financial advisor, someone who does this for a living, right? It's almost like you wouldn't go off and hire your, 15-year-old brother to, do your estate planning. You probably want to go hire someone that actually knows what they're doing, right?
Right.
So, I think people like Adam or financial planners are very important because people are not used to dealing with bigger money, and then they don't realize how quickly it could disappear.
Yeah.
And because we do have to plan for a very long period of time now that people are living for a very long time, and incapacity planning is becoming more important because going to a facility is costing $6,000 to $10,000 a month.
It's crazy, isn't
Yeah,
it?
I think it's very important to have someone to kind of steer you and tell you, have you considered investing your money in this and that, right? I do estate planning, but we do need people like, Adam to actually help people implement those plans, right? And I tell people, have you done your beneficiary designations? Actually, one of the first things I ask them. And, when they say I haven't, I said, well, you should probably make sure you do that. And when they have someone like Adam, they're probably more likely to actually follow through on those steps.
Okay, so
and avoid probate possibly.
So you mentioned a couple of times incapacity planning.
Yes.
So define that to someone who doesn't know what that really means.
For that, I would explain it as, thinking about how to allow your family members or your loved ones to make medical decisions when you're no longer able to.
Okay.
How to allow someone to pay your bills, your facility, your taxes when you can no longer pay your taxes or, pay your facility. And also making sure that your loved ones or the people that care about you have a way to call up the hospital and, in the ER when you're there, right? And with the HIPAA authorization form, that would allow people to do that. So that's how I, think about incapacity planning. And to some extent, even, doing trusts, right? Because if you do have dementia or Alzheimer's that runs through your family, a trust would allow you to save a lot of money, in guardianship proceedings in the future.
I think that's one of the things I've noticed just from the idea of engaging an attorney proactively, and the members in her team at Shutt Firm will tell you, you will pay us way less money to do an estate plan than you will pay us to engage us for probate or for guardianship after the fact. So I think that's a really good point, is if you're proactive, you may not want to part with the dollars, but your family will part with way more dollars if you wait until after the fact.
And I always tell people, when people look at me skeptical, we're very reasonably priced, and I tell them how much it will cost, and they look at me and I said, I don't make money off of making you a will. I make money off of the people that don't. And usually that'll make people realize, wow, an attorney's telling me that, if you think about it, a couple $100 for a will, we're talking very reasonably priced wills versus twice or 3 times as much for probate when I die without one. Maybe I should go ahead and just do one.
Okay, so we're going to talk about this. It sounds like, so there's tools of estate planning. But one of the first questions, I guess, and we talked a little bit about this when we talked about incapacity planning. So the overall umbrella of what is estate planning and the importance of that. Let's talk a little bit about that. Let's assume I'm a client and you're talking to me about the importance of estate planning and what it is. How would you go about that conversation, either one of you?
Sorry, you want to start?
Sure, I can start.
Yeah.
Okay, I usually ask people, have you ever done estate planning?
I think I have, right? So I would tell you that.
What have you done that you believe is
So I would tell you that I've met with an attorney, and I have the basic documents, but probably not all of them. I have a will, power of attorney, medical power of attorney, and a physician directive.
Okay.
And it's old, so I definitely need to update it. I've talked to the people who I have wanting to play roles, and they've told me, don't pick me. So they're either going to be surprised because I picked them anyway, or I need to update it, right? But so I will tell you that my estate planning needs to be updated because my brother was involved in that and he passed away last year. So that's what I've done.
So you're doing the great first steps of, attorneys will, first, have you done estate planning at all? Because most people don't, right? People come to me and they call me and they say, Anna, I want a will. And I say, okay, great. But before we get started on the will, let's think about you. Do you have a medical power of attorney? No. Do you have a financial power of attorney? No. Do you have a HIP authorization release form? And I said, you're kind of doing yourself a disservice if you don't have those, right? I don't care about your money after you die. I care about you right now, right?
Right.
So here you mentioned, you do have those items. And the next thing is, well, have you updated them? Have you looked at them in the past 5 years and thought, has anybody died? Has anybody disappointed me? Has anybody, earned a right to be in a position maybe they weren't in 5 years ago?
Or I found out like they really don't know what they're doing. Like
Or that's it, right? You realize that,
Like-
once you see other people die in your family, how important having someone who is a very good leader, who is diligent and who is honest to be serving those fiduciary roles.
So you've kind of like, if you've gone through that and helped me understand what estate planning is, I've done some of it, but I haven't done all of it. Right. Okay.
Right. We offer packages that kind of cover almost every aspect of estate planning. And I think that's the difference between people who come to me and say, Anna, I need a trust, Anna, I need a will. And I think these people probably read some articles online, but they don't realize that they're missing a lot of other things that are actually more important with them. Some examples are, I don't trust X, Y, and Z, and yet I only am looking for a will. How about a declaration regarding in case of future incapacitation, so that way my sneaky sister Susan doesn't steal all my money and get control over me, right? But if you were to talk to an attorney, you would realize, wow, that's probably more important to me that someone doesn't take control of me during my lifetime.
So in this meeting then, in addition to me understanding what estate planning is, there are different tools, and based on my wishes and what I want, then you would help me craft the tools that are necessary. So what's the best way of really going through that? Do you kind of get information about me and then decide the tools, and is it best to go?
How do you do that? I have a conversation just like what we're having, and I ask you, okay, are you married? Tell me about your kids. Tell me about your family.
No, but I want to be.
Right. I basically make a person kind of disclose to me.
I'm available. Right?
I almost sometimes feel like a therapist, right?
Okay.
I want you to tell me what your fears and what your aspirations are and who you love, right?
Okay, so let's talk about that. So I'm not currently married. I'm divorced, but there might be a chance that I'm married in the future. So that's in consideration. So if there's opportunities to create some kind of flexibility, where if something changes, it may not have to be. So that's number one.
Right.
I have my own biological child, but then I have a child that I'm claiming that's not my biological child. So I want to make sure that they're both treated as equal, and one's not shut out because they're not my blood child.
Right.
So everybody's situation is different. That's why it's important to meet with a professional, right?
That's right, because there's things that we can help you accomplish your goals, but unless I knew about all those things in your life, how would I know that, right? LegalZoom will not be able to do that for you.
Right, and then it's also important because you have these now combined families.
Right.
You have people who've been married, twice, and they have kids from separate marriages and then kids from themselves. So there's a whole bunch of scenarios out there.
And just educating clients, right? I always have to have a conversation with them, especially in mixed marriages, right? Let's say I have 2 children from a prior marriage, you have 1 for a current marriage, right? And it's important people to understand how wills can easily be changed. And that's when I tell people, do you have kids from a prior marriage? Yes, that may be a reason to get a trust. Do you have more than $11.7 million, each? No, usually, right? Do you have property in different states, right? Some people do.
That's important.
And how much do you value your privacy, or do you have Alzheimer's or dementia that runs in your family? And if any of those are a yes, that's usually leaning more towards a trust. But sometimes I get family members and they tell me, you know what, if my husband decided to disinherit all of my children after I died, because I gave him everything, I'd be okay with that. And I say, you know what, that's perfectly fine. If you feel like, if the worst case scenario happened and you'd still be happy with it and you'd think, I don't care what my husband or spouse does with all the money, then hey, I am more than happy to do a will for you. But it's about knowledge, right? Knowing that is a possibility.
And so that situation is in a situation where one spouse dies, and instead of them kind of determining what they want to do with their half of the community property or whatever, they say everything goes to my husband. And by doing that, then what goes on to
happens afterwards is
not their call.
There's no guarantee.
So they might want to clearly understand that before they make that decision.
And I think, again, just underlying the importance of a professional is if they do that in in a document they draft on their own,
Oh, that could be
there's
terrible.
clauses that may, like for instance, it would be really easy to contest that if you were a child and say, oh, she just forgot to put my name in there because they weren't specifically mentioned. But Anna and her team, knowing that they have the children, there would be some sort of acknowledgement in the will that these are her children, and she makes it specifically clear that everything is passing to the spouse.
Right, or they
Harder to contest,
realize, you know what, I didn't know you could change your will after you passed away, and then they say, you know what, I would like a trust, so that way I can guarantee that my children are also getting part of the inheritance, because, you know, I don't want to divide up my assets right after I die, because my husband may not have enough money to cover his facility costs. What if he gets dementia? What if he needs extra care? You know, so I sometimes have people coming to me and saying, I want my 50% to go to my daughter or my children, and I say, are you sure about that? Because you care about your spouse and you want them to be okay, and I want you to allow and feel okay leaving the spouse money without thinking your kid is going to be disinherited.
So what's also important to know, and a conversation that might come out with you, but not so much you as a financial advisor, is that when they start talking about their family and, you know, who's responsible enough to take on certain roles, then who's irresponsible, that you don't want to be involved in the process at all, right? And so it's very important for you to know a little bit more about the family dynamics, so that you can help guide and advise and put the right tools in place. So that's very important as well. And so you have a process of having that first conversation, which is very informal. I know you talked about before, there's a lot of places that allow you to fill out a form and you answer these questions, but those questions don't give you the information that will really help you tailor a plan and the tools and the documents appropriate for them. Right.
Anytime we see, and we kind of talk about it in the office, anytime we see an attorney who gives out a form to their client and says, here's a 10-page document, go fill it out, right? We think it's a disservice to the client, because, you know, that attorney is probably just turning on over and giving that to his paralegal, right? Or, you know, assuming things that he shouldn't be assuming. And it basically interrupts the most valuable thing of having an attorney, which is getting that opportunity to talk to someone who is a human being too, and, you know, is trying to, you know, do a good job for you. So I think, you know, that's why we don't believe in forms, and we would rather have a conversation with you and get to know you, just like you guys. Because if anything, whenever anybody comes from Adam Keller, they almost have more information about every single individual in their lives than I do. If anything, I say, please, I don't need all that.
Too much,
Too much, right? I don't need your data.
Well, here's what I want to do. Before we get into the different scenarios that I think is going to be really meaningful for our audience to really see how these tools are applied to a situation, I want to talk also about the cost. Because what I found too is that, you know, let's say getting a will and the estate planning documents in place, excluding a trust, will cost a certain amount of money, but then through the probate process, there's additional funds that will have to be paid upon for probate. Or you pay a little bit more to get maybe some probate alternative strategies in place, possibly, if it's a trust. But then upon your passing, you don't pay as much because you don't have to pay court costs. So navigating through that, you still need to make sure that you get enough information to recommend to a client. But what can you tell us now about the cost of going through, meeting with you and probably going through those strategies?
Well, luckily you live in Texas, right? So let's start with estate planning. Estate planning attorneys kind of vary. We're actually very affordable. Well, when you're looking for an estate planning attorney, it's all regional. So every region in Texas, for example, has their range of how much, you know, they pay attorneys. You know, I've heard, for example, that prices in Frisco for estate planning attorneys are actually higher than the prices in Richardson or prices in McKinney, right? But for around the base level of what you can expect for a will package, which includes a will, a medical power of attorney, a disposition of remains, an appointment of guardian case future incapacitation, a HIPAA authorization release form, and a couple more estate planning documents, you're looking at starting rate of $800. So if you find an attorney willing to do that, you're doing really well. And in the high end, it goes up to $1,400 for just a will package. When you add on trust, you can go from, you know, as low as $800, $700 plus, you know, thousands of dollars, right? So it's all about finding someone who has experience. So the nice thing about the Shutt Law Firm is, yes, we do estate planning, but we don't do estate planning exclusively, which, you know, sometimes can be benefit if you are more high net worth. But the thing is, when you have attorneys that only do estate planning attorneys, you know, they actually miss bigger picture items. They don't realize that this gets litigated often, and maybe I shouldn't be doing my estate planning in this way. So you're getting a really good value at the Shutt Law Firm because we do have more angles. We do guardianships. We know what it takes to keep you protected, right? And away from a guardianship. We do probate, so we know how to avoid it more efficiently.
And then what should people expect when it comes to the cost of probate versus avoiding that for their family members after the fact? What's the range for that?
So it just depends. I mean, to me, because we are so affordable with estate planning, I always like to pitch our alternatives, right? I say, look, you have your will as your safety net, but if you have a survivorship agreement or a transfer on death deed or a ladybird deed, which could only cost you $150 each, you can maybe avoid probate because your house will be transferred automatically. Adam Keller's people will help you figure out who your beneficiary designations are. And if at the end, when you pass away, your wife or child says, well, I have all the money from beneficiary designations, the house was transferred over to me, through a transfer on death deed or survivorship agreement, they may realize that once they talk to us over the phone, we could say, well, luckily I don't think you need to do probate, right?
Right.
So that could be done very efficiently, maybe even under $1,000, right? Because
Right.
with a couple. But the other alternative is I always talk to everybody when they come in. I say, have you done your beneficiary designations, right? That's free. And people say,
Right.
well, how much does that cost? And I say, well, you don't have to do it with me. You just go talk to the bank, right?
Yeah.
The other alternatives, the transfer of death deeds, I think it just varies between, law firm to law firm, but we like to stick around, $100, $150. We want to make you want to do it, right? And that way it helps your family. Do you have any other beneficiary?
No, I think to his point, sometimes they wonder, okay, I'm paying this money up front versus what if my family goes through probate?
Yes.
And I think probably it depends on how contentious the probate is or how complex the asset structure
I always
is,
ask
right?
people, if you're going to have anybody fighting it, you can do a will, but are you sure you want to do that? Because, I've seen so many cases where I've thought to myself, people could have avoided all these fees if they would have just made a trust. And so we always say, apart from, how wealthy you are, or if you have mixed family, are you planning to disinherit anybody? That's another really good reason to get a trust. But probate in Texas, we are more reasonable in the probate end too. So, you're expecting a probate cost of around $2,000 for a whole probate. To get you to probate, to get you your letters testamentary. If you die without a will, though, you're looking at between $3,500 to $7,000 at a high law firm. At $7,000, we're looking at more $3,500 to $4,500. That's our range.
So I think even that right there is a great example. If they're going to do your simple will kit for $800 and in a low range you're going to pay $3,500 in probate,
Yeah, you can't
the
beat
delta's
that.
there.
You can't beat that.
That's legitimizing what she tells to the client
Right.
on you cannot do this, but you can pay me more in probate.
Right. I've had people that come to me and they said, my dad died with the will. They bring me a 30-page will. And they said, look, this attorney wanted to charge me $7,000 to do probate. And I think, what?
Wow.
And usually ours is around $2,000. And it's just, I always tell people just, buyer beware, right? If a probate attorney is asking you to sign a contingency fee, although you are more than willing to pay for an hourly rate, you should consider that. And I hear that it's more prevalent in the South, in Houston and other places where people do not trust probate attorneys, but you shouldn't be afraid of consulting a probate attorney, especially since they do free consultations and you have a right to read your engagement agreement before you sign on.
Yeah. So what I want to get into is your scenarios, and I'll just tell you, I went through a probate process. I went through a passing of a family member who did not have a will. And I talked to all my friends and attorneys, and their advice to me was to not even go through probate because he was able to identify beneficiaries for his life insurance, for most of his accounts. He did have some small checking accounts that we had to fill out some kind of affidavit of heirship that allowed the banks to go ahead and give the money to the beneficiaries without going to the estate. And then his car. He had something on it to where it paid off the loan. And so we had a DMV affidavit of heirship to pass the title on. And he didn't have any real estate at that time, right? He had sold it. But for the most part, the only thing that was in his estate was his debts.
Right.
And so it just did not make sense to pay the $2,000 to go through probate or
Right.
$3,500 for an intestate probate, and all you got are debts, right?
Right.
And so I want to go through some examples to really help people see the application of these tools that you've talked about in a scenario where someone
Right.
has money, probate avoidance, alternative strategies, and then maybe some high net worth individuals or middle class individuals. So what scenario do you want to throw out first?
All right, well, let's get started with the college student. You know, I
Okay.
think here people are watching this and thinking, oh, but I am so young, I don't need this. I'm going to live forever. Maybe not during COVID though.
Right. I'm going to the Firefly Festival. I'm living it up, baby, living it up.
If anything, I think what COVID has made people realize is, you know, I should worry even about my kids, right? And I think, look, you know, the first thing is, you know, Bobby turned 18, right? And he left home for college to UTD. This is actually a phone call I had not too long ago. Bobby's having a hard time adjusting, and Bobby's parents find out that Bobby has been admitted against his will to the mental institution in a county nearby. They call in very panicked. What can I do? They won't tell me anything. They won't even tell me when he will be released. I get at least probably 10 calls a year about this, right? College students. And here the thing people are realizing, or the parents are realizing, is my child is an adult. I can't get medical information over an 18-year-old. I can call in and tell him I'm mom, I'm dad. The institutions don't care.
Right.
Right? So here is an example of how estate planning is actually bigger than you think, right? Number one thing that child could have had before he left for college is a HIPAA authorization and release form. If you would have had a HIPAA authorization and release form, then the mental institution would have actually given you the information about why he was in there, how he's doing, what medicines they're putting him on, when they're going to release him.
So let's talk about that a little bit. So that form does what? It actually assigns an agent. Explain to us what that form is.
It actually authorizes certain people on that form to get medical information about that individual.
And it can be more than one person?
That's right. So
Okay.
when Granny has dementia and nobody knows what Aunt Susie's doing, if they would have had a HIPAA authorization and release form, then they would have also known what's going on with her.
Okay.
In this case, it would have been a college student who would also have, you know, their parents would have been able to know what's going on with them.
Okay.
Right? But they're adults, so you know, there is a protection. You know, we have HIPAA laws to protect their medical information, regardless of who you are.
So every parent out there with an 18-year-old, you don't have a HIPAA release form, you need to get that done because you never know when your son may be, or daughter may be admitted to any kind of facility, or you just need to know what's going on health-wise with them.
Or, you know, they could get hurt, you know, if they're in sports, you know, and they have an accident in college, I mean, when you call up that hospital, that ER, you know, they're not going to tell you information. My husband always likes to give me that example of when he had his appendix removed, and his mother, they called his mother the hospital, and they wanted her to pay the bill, and she paid the bill, and she asked, you know, for some information. They said, no, we're not going to give you any information, HIPAA law. And she said, I just paid the bill. They don't care.
Yeah.
Wow.
They don't care. So, you know,
Wow.
do your HIPAA and then also do a medical power of attorney, because, you know, if your son or daughter does have an accident and they become incapacitated, they still need someone to make those medical decisions for you. And, you know, there's nothing worse than doing a guardianship over someone who is that young when that could have been avoided.
Okay.
Then the other thing would also be while you're at it, already go ahead and do a financial power of attorney, because, you know, when you're out to college, mom and dad might be able to help you with some, you know, banking stuff that you need them to do from far away.
So that's interesting, because what I've done for my financial scenario is there's a financial institution that allows you to fill out a financial power of attorney that's only for that financial institution. So it's not broad.
Universal.
Yeah. And what it does, it allows them to be an agent now,
Right.
as opposed to only being an agent when I become incapacitated.
Right.
Because if you have one of those forms, you have to then prove incapacitation, which may take some time,
Which
right?
is why we at the Shutt Law Firm don't actually recommend, and we don't like to make springing powers of attorney.
So what do you recommend then?
We actually make them effective immediately.
There you go. I want to make sure that point, and so that means the person you're identifying needs to be someone that you trust now.
Absolutely, that you trust and would never steal from you, even if you were in a coma. I always tell people, right? So if your Aunt Susie she might steal your money if you were in a coma. Don't put her on.
Yeah, right.
Parenthetical reference, even if you were in a coma.
Okay, so that's important to have. So you talk about the medical power of attorney, financial power of attorney, immediate financial power of attorney, HIPAA release form, What else?
That's it. That's what I would recommend for a college student.
Okay.
Right? Now let's go on to our next
But
scenario.
before you even go there, though, that's for today. But what about the other, like a will or anything like that
yeah, I
for this college student?
Right. Just because you're 18 doesn't mean that you don't have an estate, right? Which gets back to, even a homeless person has an estate, right? You do own things, right? Let's say a lot of the time you'll say, well, my son, 24, passed away, had a bank account with $5,000 in it, right? And we'll get to that that's next scenario. I always tell people, if people die without a will, it's and no beneficiary designations. It's kind of sad because it does take around that $4,000, that $3,000, $4,500 to probate. You're not going to want to do a whole probate over $500.
So before we move on from the 18-year-old, because I have a college student, right? And so if we have all those forms in place in the event that he just becomes incapacitated or we need to get access to his medical records to make a decision financially, that's great. But then if he passes away, and let's say he hasn't designated a beneficiary on all of his financial accounts, it's not like he has a 401k. So it still might be a situation where his net worth or the value of his estate is not greater than the cost of probating.
Right.
What kind of strategies do you recommend for someone who's that
that's
age?
when we go to beneficiary designations, right? When you go to set up an account for your daughter or son, have your son or daughter put you as a beneficiary designation on those accounts.
To make sure everything of value from a financial perspective goes to a beneficiary or person or whoever it wants to go to.
And then when we get to those alternatives, then we'll also go, if your college student does own a vehicle, go to the Texas DMV, and if you type in Google Texas DMV beneficiary designations, you'll actually have one or two forms that allow you to name a beneficiary for a vehicle after you pass away.
Okay.
It's almost like having a paid on death beneficiary on your bank account. It'll give it to your person, when you die.
And then when it comes to anything that's his personal property that does not have like a legal title associated with it, if at that point you got to be careful. What do you recommend?
That's a little bit more loosey-goosey. I think it just depends. It just depends, right?
Because sometimes you find that people, when someone passes away
after someone dies.
You said it. That's all I was gonna just come in and take stuff, right?
So that's when I tell people, make sure you lock the doors.
Right.
Because that is really one of the biggest and the saddest things. Mom died, and everybody came over and took everything.
Gotcha.
And people will tell me, well, they took this and that, and I tell them, is it really worth talking to an attorney for the value? Like, how much was that couch and that stereo worth? Are you looking at $800? And I hate to break it to people, but it's going to cost more in attorney's fees than that property.
Okay.
But it is very important that you're careful about beneficiary designations on safety deposit boxes, right? Or that if you do have jewelries or mom gets dementia, where do you put these valuables that are worth thousands of dollars? So
lastly, for this situation, what would you say people should expect to pay for something like this for a college student?
Well, they can either look to their public resources. For example, if you live in Collin County, a lot of these things I've mentioned, the medical, the financial power of attorney, and the HIPAA authorization is probably available, maybe even for free in Collin County.
Oh, okay.
If not, if you go to an attorney, which I would recommend, especially for the durable general power of attorney, there's nothing like having an attorney help you out with this. You should be expecting between $200 to $300.
Okay.
I wouldn't pay more than that.
All right, that's good. That's good to know. So thank you.
Okay, so the next example, do you want to read this one, Adam?
No, I think you carry on, and I'll just add flavor when we.
Okay.
It's like in a class. Well, read. Why don't you read this, Adam? Yeah. Participate. And then Adam's going to say, "No, you got it."
I got it. Okay, so let's go to the reoccurring topic here: incapacitation.
Okay.
I think this is the most important part. So here's an example. Dan lives with a girlfriend, and he's been living with her for 15 years. Living at home. And he has 3 siblings, and they all live all over the United States. Now, Dan does not have medical or financial power of attorney because he's around 45 to 50 years of age, and he thinks he's young and he's never going to die, or that he's young and he'll do estate planning later. So Dan has medical insurance through his employer, and Dan owns a home with a mortgage. He is the main breadwinner, so although he lives with his girlfriend, he earns most of the money. He has around $40,000 in savings, and I think that's actually more common now, right? You know, there's a lot of expenses.
It's common for some people, right? Like somebody like $40,000.
Yeah, I mean, $40,000. I mean, you know, he was doing pretty well, right? But then he had a stroke.
I got you.
And unfortunately, because he did not have a medical or financial power of attorney, nobody has been able to get any information regarding how he's doing. That way, you know, if we had information about how he was doing, then the family could also make decisions about what kind of treatment he should get. Also, they can't contact the medical insurance through his employer because they don't want to release any information to them. And they don't know how to make the mortgage payment or access his funds to be able to pay his electricity and all the utilities of the home. Even the, live-at-home girlfriend can't access that information. So the family calls me, what can we do? And basically I have to give them that hard conversation of, if your family member did not have a medical or financial power of attorney, the only way to get these institutions to listen to you and to open up and give you this information and allow you to, pay your facility bills for that person, pay the medical bills, make these treatment decisions, is really to do guardianship. And what people don't realize is that some counties take a lot longer than others. So this family was very fortunate. They actually, their family member lived in Collin County, so we were actually able to help pretty quickly, but they might not be so lucky in Dallas County.
Got you. So in this situation, they were able to file for guardianship through the court system.
Yes, you have to go through court.
Yes.
And in Dallas County, that could take for a regular guardianship, which is called just permanent guardianship. There's two types: of the person to the estate. The person, you get to make your medical decisions, where the person lives, and things like of that sort. Or the financial power, the guardian of the estate. The guardian of the estate just handles the financial aspects of it, so the money.
Gotcha.
In Dallas County, that process can take anywhere between 8 to 9 months.
Wow.
To get a guardianship.
And so what happens to the person's bills for that period of time?
Good question.
Right.
That can be kind of hard. Sometimes I have family members that have to just pay the bills for that person. But if it's not an emergency, then it's not an emergency, right? The other kind of guardianship is called a temporary guardianship, right? The two types of the person in the estate. So let's say you do have that family member and they're gonna get evicted from that facility if they don't pay their bills. That's a reason to go to the court and say, look, this is an emergency. This person's gonna be hurt. This person's in imminent harm and they need help.
So in addition to having these legal
so that will take less time. I want people to know that within a month we can help that person out.
But in addition to having these legal documents in place, what's really important, what I'm thinking of, is that how many people know my process for paying my bills?
Right.
Because everybody has a different process. And I've actually helped, some family members. I had to come in and kind of help them identify a process as a financial advisor. One of our colleagues told me, Clifton, when clients come to you, they're asking you for your advice. So why don't you show them how you manage your stuff? And so a lot of times, the way we manage our stuff is so personal.
Right.
Nobody knows.
Well, it's just a lot of work to keep up with it all.
Yeah.
Right? I'm not gonna lie, right? You have all these bills coming from all sorts of places, and sometimes it's hard to just sit down and write them all down. But
it is important if you want to be responsible. So if I want to be responsible, and I've done this once, but I want to make sure that if someone has to come in without any of my assistance and look at how I'm managing my finances, I should be managing it in a way to where someone can look at some document and keep things current in the event that I'm incapacitated.
I think my dad always told me as a kid, in a managerial position, you can tell you're a good manager when your business runs really well when you're not in it. And that's a great thing and phrase and thought process to apply to this, right? To your point.
If your household can run without you.
Can your household run without you in it? And if you've shared information with a spouse or with a child or a significant other, obviously somebody that you trust, that's a really important piece. And like you said, I think we noticed that too, is that we tend to be guarded about that. But an estate plan is more than just the documents. It's these conversations.
Yeah.
And so that's a really
I often
valid
have to
point.
tell people, look, you have as much privacy as you'd like, but there is a certain point where if you are so private about things, it's gonna come back and hurt you.
Right.
Because if you have a stroke like this man, the fact that they didn't know where his mortgage or his insurance or all these things were coming from, that hurt him.
Yeah.
So, through that generation who doesn't want to tell their kids anything, I don't think they're doing themselves a service at all.
Well, you're going to address this later. I want us to go through some more scenarios, but I think there's a problem if someone looks around and says, I ain't going to trust my kids, like they don't have anybody, then that's like another.
That's another conversation
Quandary,
to have
yeah,
with them,
yeah.
right? About what their options are.
Right.
So right here, at least for this scenario, I think if Dan would have just had a medical or power of attorney, he could have made one of his siblings that, or that living girlfriend, right?
Right,
But instead, they had to pay probably over $10,000 for that guardianship.
Which is
when it would have
crazy.
only have cost him what, $200 to $300?
You're right, exactly.
Yeah.
Okay, that's a good scenario. Because look, that scenario, it's not isolated.
No, I get this scenario.
You're not alone. You're not alone.
I get this scenario, 4 times in 2 months.
Yeah.
Yeah, and I take on half of those cases.
Got you on that.
So it is quite a challenge. Now, you ready for the next one?
Yeah, for sure.
All right. Does the state of Texas keep my money? I just had to address that.
Okay.
Maybe I should have done that at the beginning.
Yeah.
But the most popular thing I get is, isn't it true that the state of Texas keeps my money? No. The state of Texas does not keep your money. But if nobody claims your money, let's say like you're, that family member of yours who had that little bit of money in the bank account and it wasn't even worth, doing probate over, that money will go to the Texas Unclaims Fund. So after someone dies within maybe a year or 2 or 3, it wouldn't hurt to go to Google Texas Unclaims Fund and look them up. You'll realize that maybe there is enough money out there in their name that you might want to do a probate, or you might want to reach out to the Texas Unclaims Fund and get that money back.
Well, let me ask you this, because there was a case where you do that, you find that there's some money out there, the person is deceased, has 2 kids. Is there any way to claim that without going through probate?
Yeah, there is. So
Okay.
the Texas Unclaims Fund has their own. So sometimes when people come to me and the estate is worth so little that no probate is worth it, I tell them, look, just wait till it goes to the Texas Unclaims Fund and just claim it directly from them. Because that, that affidavit of heirships you were talking about, they have
Yeah.
their own versions.
Okay.
I recommend those less with banks because some of them say they'll take them and then you'll make them and then they
They
don't want
don't.
to take
You're right. Yeah. These 2 banks were very reasonable. They kind of
that's the hard part, finding reasonable banks.
Yeah.
Right.
Yeah.
And every institution is different. So
Right, and I tell them, look, a probate attorney can tell you one thing, even Adam can tell you one thing, but at the end of the day, it does come down to what the institution will allow you to do.
That's true.
Right.
That's true.
All right, so let's see. So that is a common misconception. The next thing that will feed into that first slide about incapacitation is that living girlfriend for 15 years, right?
Yeah.
Another important thing for people to keep in mind is we do live in Texas, and for a lot of people that have been moving down from California, Illinois, Michigan, all these other places, is that Texas is a common law state. So, that girlfriend who was just
community property, right?
Yeah, community property, right?
Yeah,
Well,
yeah.
that girlfriend that was just a girlfriend when he was alive suddenly starts announcing herself as his wife once that person dies. So it's also very important to do your estate planning because if you think, look, this really is just my girlfriend or my boyfriend or this is really my wife, I have 3 kids with her, I've been with her for 20 years. It's important to realize that Texas is a community property state. And that's why I've also attached this little diagram. This actually outlines how your estate is broken up into if you don't decide how it is. So, that's when I come. People come to me and say, "Look, my husband passed away. He had 2 kids from a prior marriage. The only thing I own is my house." I have to tell them the very unfortunate news: how they now own the house with the 2 stepchildren.
Yeah.
So, it's important to make sure that you do address this, especially with a mixed marriage.
So for someone to claim common law, they have to present themselves.
Yeah, present themselves as married, right? So if me
Right.
and Adam were married, I'd say my husband,
Right.
my wife.
As opposed to my girlfriend.
Right.
Okay.
Number 2, we would have had to have an agreement that we're married.
Could the agreement be verbal?
Definitely.
Okay.
Then the third one is that we have lived together for any amount of time. Another very common misconception, which people think, well, they've been together for 6 months, or the last one I got last week of they've been together for 10 years. And I think, where are they getting these numbers from?
Right.
No, it's just those 3, any amount of time. We could have lived together for an hour for all we care, right?
Wow. But so is it all 3 of them or any of those 3?
All 3.
Oh, it has to be all 3.
Right. So usually when, let's say, Susie passes, she dies, her husband really, they did do all those things. One of those things that he may have to do apart from a determination of heirship is have a declaration where the court acknowledges that Dan was the common law spouse of Susie, right?
Gotcha.
So there was an informal marriage and they will be recognized as the wife or husband. So what I've done in the past is when a person says, look, I love this person, they are my husband or spouse, I put in their will, Susie is my wife, right? And that I feel is evidence to show that.
Okay.
Alrighty.
I think you hit on a topic that we see and hear often, and anytime we're meeting with a client who is from a blended family, meaning there may be children from a previous marriage, not having that will is such a detriment to that family. And we always tell the client, look, your will is your playbook or your set of rules that you are giving to the court system, because if you don't give them your set of rules, to Anna's point, they have their own set of rules, and you could inadvertently have children who are your co-owners in a house, and if everything's amicable, no big deal. But the minute there's one child with whom you may not agree, they can force some issues there that may not be so comfortable. So that, I think for any of the viewers who may be in a blended family situation, you have even a higher degree of urgency to make sure that you have some degree of estate planning done.
And especially because you want to have those people continue to be happy and talk to each other afterwards, right? Because the most common thing is, well, their wishes were, well, they told me. And I have to tell them the very unfortunate thing, which is, look, if you're going to be appointed as the independent administrator or executor or whatnot, you have to understand that it does not matter what their wishes were, because that's not what the state of Texas outlined for them, because they did not do it for themselves. So it's unfortunate, but it was not written down. It's just sad, because we do want their wishes to be heard, right? So it's important to do their estate planning. Or just make a will, even if it's a holographic one. So let's do, when do attorneys recommend trust, right? We've been over children from prior marriage, real estate in different states, family history of incapacity, centralization of control of assets, privacy, and disinheritance, right? The one thing we haven't covered, because we covered a will and whatnot, what happens without a will, right? Let me give you an example.
Okay.
Jack has a wife and he has 2 sons. Jack owns a 401k and his bank accounts without beneficiary designations. Jack owns a house in Dallas County. How long do you think this is going to take in Dallas County? Do you have an idea? Yes.
6 months.
6 months. That's what I'm thinking. I was going to say
Without
6
a will.
months.
You're looking at 6 to 8 months in Dallas County.
Wow.
Collin County, 2 to 3 months. Jack dies with a will. Dallas County, 2 to 4 months. Collin County, 2 to 5 weeks. That's to get you to understand that, wow, I may want my family to be able to do something about it, so maybe I should think about a trust. So that's one of the bigger reasons why someone should now consider a trust that wasn't here before, which is, do I live in a county where probate will take a very excessive amount of time and nobody will be authorized to deal with my mortgage lender or access those funds into those accounts?
Gotcha.
So that's one of the reasons. In the next scenario, okay, Jim owns a home, right? He has a father and 5 siblings. Jim has a girlfriend. Jim passes away, and his girlfriend declares at the funeral home that she is the wife.
Okay.
Can the family stop her from bearing that Mr. Jim and declaring that she's a wife?
Is it true though, or does it matter?
Doesn't matter. That is the one thing we'll learn the hard way, which is a funeral home can rely on someone's claim that they are a common law spouse, right? And this was devastating to this family. It took probably 2 months to get this body back, around $6,000.
Wow.
So it's very important that if you do have a girlfriend, long-term person, but if you desire for someone to be that person to bury you, to go ahead and do a disposition of remains. You can appoint an agent for a disposition of remains.
So is that just one of the additional documents in addition as part of the estate planning
Yes,
process?
it's not part of the will. People often misconstrue that, and they're like, well, where do I put it in the will? It's a side, right? It's called an appointment of agent in case for disposition of remains.
Okay.
Clifton, one of the slides that we passed on to you is an infographic that we created, and in the bottom right corner, somewhat obscure, it says for estates that are over that $11.7 million
For each
level,
spouse.
Exactly, that Anna referenced, you may consider a deeper toolkit. Actually, it need not even be over that 11.7 million. Maybe you have a really closely held business.
Yeah.
Maybe you've got farmland. Maybe you've got property in multiple states. And so there's some complexity and nuance to the way you've structured your wealth. sometimes, even though you may not necessarily even be subject to estate tax because they have what's called this portability feature,
Right.
where let's say Clifton's married now because you're seeking that woman and you found her, and you have 12 million, you can pass her the 11.7 million as a spouse completely
And
estate
avoid,
tax free,
yeah.
even though it exceeds that 11.7 million. But you and your spouse each have what's called a credit exemption, and think about it like a coupon. So if you turn yours in at your death, you can get that full 11.7 exempted from estate tax, and it's not charged estate tax again. There's some rules and ways that that works, and we work typically with an attorney to file an estate return. We work with a CPA, but there may be other things that we use instead of portability that come back to understanding your situation, and we may go, man, one of these assets I don't want to sell in this process, and so if I can put it into something like a family limited partnership, there may be ways to gift it while still maintaining control of all the voting rights in my company. So my desire to maintain control while still making sure it gets to where it needs to go elicits the need for a more complex suite of tools, right? There's so many little complexities that come into that. You may have charitable giving goals, right? Maybe you had a really banner year and you had a lot of stock options that hit and came vested, and you got 1.2 million in income this year, and you want to give a gift to your church, but you typically only give them 20,000. This year you want to give them 100,000. You could put it in what's called a donor advised fund, get the full deduction this year, and then you could dole those funds out for the next 5 years to the charity. So they still benefit in the same way that they always did. You just knew the way to utilize it in a more tax advantageous manner to yourself. So again, that bench and suite of tools can be really robust. And I think by understanding the client's situation, we get to come in and give some other ideas on some of these strategies that may be to their benefit.
So the value, again, in working with professionals is that no matter where you are on the wealth ladder,
Spectrum.
right, there are strategies in place to ensure that your wishes are followed in transferring your wealth, no matter what level it is, to your beneficiaries, and it mitigates the emotional distress of decisions having to be made at the time where they're grieving your loss.
Exactly.
Right, which is very, very important. And all of the information you shared, like there's a PowerPoint slide, that a PDF version that's available underneath the video, like your infographic is down there as well. I also want to make sure that your contact information is down there. So in the event that we talked about anything here that requires more information from you and our audience wants to get in touch with you, how do they get in touch with you?
I will make sure that they've got my email address in there, my office line as well. By all means, feel free to reach out either way.
Okay,
I'll be happy to respond.
so what is your do you have a website, or so what's your website?
Website is www.threeoaksag.com.
Okay, so they can just Google you and say Adam Keller and
Three Oaks
like
Advisory.
the real Adam.
Please stand up.
Right. And then how do people get in touch with you
So
usually?
the best way to get in touch with the Shutt Law Firm would be at www.shuttlawfirm.com. That's
Okay.
Shutt with 2 T's. The nice thing about our website, it actually offers an online calendar, so you can actually go ahead and book directly with an attorney, pick the time that works for you, and it's a free 30-minute consultation.
I was going to ask that. So you provide a free consultation as
That's
well?
right.
Good. Do you provide a free consultation?
We do, and we even start off with a phone conversation too, because sometimes clients may be coming, we have clients in 21 states, right? So they may not need to come in necessarily for the first
Right.
appointment.
Yeah.
And so we're always going to start off with that initial conversation. Both that conversation and the initial meeting, we look at as time to basically explore whether or not there's a basis for working together. So it is complementary.
So really the misnomer is that just getting advice doesn't cost. It just costs your time.
Right.
So if people are watching this and anything has percolated or idea, it will be use the resources that are available. Like at least get a 30-minute consultation, get some advice, because it will pay dividends in the long run.
Right, and sometimes, people don't become our clients, but we tell them, go here, go look up that, or go to Collin County, or do this and that. And
Right.
just that, I always tell people it's invaluable, right? The free 30-minute consultation. We'll be more than happy to help people.
So look, we can talk forever, right? So I want to give you an opportunity, if people are like fast forwarding, they get to the very end of this, I want each one of you to have your closing comment of what's important for people to know as a result of, our conversation, our topic today. What would your most important takeaway be?
I think a couple of points. Number one is that the time that you spend today being proactive around your plan will be amplified in terms of the amount of time it saves yourself, your family, your heirs in the future. And the hardship that you mentioned, I've seen it in my own family where they're left to guess an intention. It's amazing how much intentions vary in perception of those left behind. And then the other thing I would say is just, it's an ongoing process. So Clifton, if your viewers go and do this and they get their estate plan in place, it's not a one-time and done.
Yeah.
Don't forget to go back through that estate plan from time to time. And when changes occur, review your estate plan. Did you set up new accounts? Did you buy new property? Did you move to a new state? Did you marry somebody? Did you divorce somebody? Did new kids come into play? Any of those life changes should probably warrant going and speaking to your professional.
Right.
Most definitely.
And don't be scared to talk to an attorney. We're very nice, actually.
She's been nice, right?
Mr. Shutt especially, he is so nice. Everybody always loves him. And also, our estate planning usually just takes 2 appointments. The first one is to collect information, to talk to you, and then the second one is to review the documents and make sure they're exactly what you wanted. But you know what the comment is said after this is all said and done, after the 2 appointments is, wow, this was easier than I thought it was going to be.
Yeah.
So, and I always say, I don't know why I waited so long. So do yourself a favor. It'll be very easy.
Oh my gosh. Well, I'm telling you right now, thank you does not say enough about my appreciation for you guys taking time out of your lives. You both have family and, you need your time after you've been on the front line for so long, right? So I definitely want to appreciate and thank you for sharing your wisdom and your time with the Empower Series community. What I hope is that you get a bunch of calls right now from people who've watched this and are taking action or inspired to take action. I know I am. We're all human. We're not in this alone. We all have to take care of our own stuff, financial stuff, estate planning. So you've given me ideas that I am inspired now to take action on. And I'm putting it out there on blast. I got to get my stuff updated, right?
Right.
So definitely thank you. Thank you for spending the time and watching us here on the Empower Series. Our intent is to give you hope that your vision of what you would like to have happen for your family can happen. Inspire you to take action, not sit on this. You have ideas, act on it, ideas in action. We definitely educated you. You can look at this over again. Definitely share this with your family and friends. Below there are links to additional information because we can only go through so much.
Right.
I really encourage you to stay connected and to make an appointment. Or just call, do something. If it's not Anna and Adam, then talk to someone else. But get information and take action. But thank you so much for paying attention. Until we meet again, I would like you to be empowered and inspired to thrive. Thank you for watching our Empower Series YouTube video. I really hope you enjoyed it. Remember to hit the subscribe button below, as well as the little button to be notified the next time we upload our video. Until then, stay connected with us on social media, Facebook, Twitter, Instagram, whatever your social media flavor is. Inspire the world to thrive. See you soon.